Why did that freeze up? There we go. Hello, everybody. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me as he does every other Friday, Alex Ooley from the Forge of Freedom podcast. Alex is an attorney in Southern Indiana. Alex, thanks for joining us today, man.
Great to be with you, Paul. Thanks for having me.
Absolutely. Let's go ahead and get started. As we do get started, I want to remind everybody, if you want to get your comment in, if you're watching on Polite Society Polite Society Podcast Facebook or YouTube page, go ahead and comment directly on those videos. If you're catching us anywhere else, if you're catching us on Rumble, where we're getting a very good following, if you're catching us on OpsLens, Getter, anywhere else, go to Twitter, tweet with the hashtag #TheBullet. Get those comments up here in my peripheral. There we go. We're already getting check-ins coming from YouTube, and thank you for that. Alex, first couple stories are stories we have covered before, but as usual, when I'm covering something that's heavily legal, I'm going, boy, I wish Alex was with me. So I'm going to go over a couple of these again. First one from New Jersey. I got this story. This, I believe, was from Wednesday off NewJerseyMonitor.com. Just going to read just a little bit of it. New Jersey officials plan to appeal a federal judge's orders blocking parts of the state's new gun law. Attorney General Matt Placken told federal judge Renee Marie Bum he will appeal her 2 temporary restraining orders allowing guns in places state legislators banned them, including bars, parks, beaches, and libraries, even though such orders aren't ordinarily appealable. And the story goes on down here. He was basically saying later in the story, as I read it, look, if you rule on this quickly, I'm going to withdraw the appeal, but we want you to get on this. And there was a quote in there from Scott Bach of the New Jersey Association of Rifle and Pistol Clubs saying, look, we're going to win this. The state is just, wasting taxpayers' money here, but we're going to win this. Alex, this seems to me they've got to know they're going to lose this, but it seems like they're just grasping at straws, trying to delay it as long as possible. Am I off base there, or do they actually have a leg to stand on?
No, I think you're exactly right, and I think Scott Bach was right when he said they're basically wasting taxpayer money to defend something they're going to ultimately lose, whether that's at the Supreme Court or at some lower level court. Here, the court issued temporary restraining orders, and before a court will enter a temporary restraining order, the court has to determine that the plaintiff is likely to prevail on the merits. There's a substantial likelihood of prevailing on the merits. And the judge found that here, and I think that's the correct interpretation in light of Bruin. And New Jersey here, much like New York with their Concealed Carry Improvement Act, is basically just throwing a fit because they didn't like the ruling from the Supreme Court in NYSERPA versus Bruin. So this is just another example of that. They're trying to call or designate sensitive places for things that I think, for places that are clearly not sensitive places as demonstrated by the history of the Second Amendment, and places that would have historically been prohibited don't include this laundry list of places that New Jersey and New York and other states have tried to designate as sensitive places.
Absolutely. Because I want to get through these legal ones a little, because we've got. Let me get a couple comments in here real quick, and then I'll explain why I want to hurry. But 500 Magnum says, that's the first time I've ever seen you without a hat, Paul. Well, it happens from time to time. It's very, very warm in the studio today. And what you see reflecting up here, that's the lights of the studio. That's not the sun. But regardless, it is very warm in the studio today, and I just decided to forego the hat. And he also says Michigan is pushing everything more gun control. This insanity must be stopped. We've got a story about that coming up, and there will be a story. I was working on the stories for the weekend bullet for tomorrow. There's a story here today and a story in that one. We're going to be talking a lot about Michigan in this show and the next one. But let's. I want to get to some of those stories. Let's go ahead and Alex. Next story I got. This one hit yesterday. Florida, a federal appeals court on Thursday upheld a Florida law passed after the massacre at Marjorie Stoneman Douglas High School that raised the minimum age to purchase a gun from 18 to 21. The 3-0 ruling from the 11th U.S. Circuit Court of Appeals comes as the age-based restrictions are shaping up to become a flashpoint in the legal battles over gun access since the Supreme Court last year laid out a new test for determining a gun restriction's constitutionality. I'm going to skip down just a little bit. In an opinion written by Circuit Judge Robin Rosenbaum, the panel concluded that the Florida law was consistent with our national historical tradition of firearm regulation. Alex, the Fifth Circuit found the exact opposite not that long ago. This, I believe, is good news for us because this sets up a circuit split, so it's more likely that the Supreme Court will take this up. What do you think, man?
Yeah, that's exactly right. So the Supreme Court has many cases that are appealed to the Supreme Court, but the Supreme Court can't hear all of them, and they have to prioritize the cases that they hear. And one of the ways that they do that is when there is disagreement among the intermediary federal circuit courts. And where there's a disagreement among those courts, the Supreme Court has an incentive to resolve that dispute or that disagreement, and that's called a circuit split. So here we have the Fifth Circuit and the 11th Circuit that disagree. The Supreme Court is likely to take up that issue at some point. And I think is going to side with the Fifth Circuit. The Second Amendment, as we all know, says that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And the people, I think, clearly includes people between 18 and 20 years old. So I don't think there's any historical tradition to suggest otherwise. And here the court points to some regulations regarding age restrictions after the 14th Amendment was adopted in the late 1800s. But that's not the period of history that we look to. At least it's not the period of history with the most persuasive authority. So we look to the time of the founding. We look to 1791 when the Second Amendment was ratified, and there is no historical tradition at that time restricting the right to keep and bear arms based on being 21 or older.
Thinking of going back to 1791 when the Second Amendment was ratified, we just come out of the Civil War, and I believe, I got to do some more research into here, but I believe you could join the Army at the age of 16. And again, back then you brought your own weapon to the military. You didn't get issued a gun when you went into the military. You brought your own. So I think there's an argument that 16-year-olds ought to be able to buy and have their Second Amendment rights. And it's gone, lately everything is based off of 18, but...
Yeah, after the Revolutionary War, I think there was I may be wrong on the exact name, but there was something like the Militia Act of 1792, right after the Second Amendment was ratified, that basically required able-bodied men between the age of 18 and 40-something, I can't remember the upward end of the range, but to have a firearm so that they could bring their own firearm for militia service. So I think clearly the historical tradition suggests the exact opposite of what the 11th Circuit decided here.
Absolutely. One more legal story, then we'll get into the regular news. Michigan leading that news, but federal judge strikes down Missouri gun rights law. A federal judge has struck down Missouri's Second Amendment Protection Act, finding the law to be an impermissible nullification attempt that violates the Supremacy Clause of the U.S. Constitution. SAPA's practical effects are counterintuitive to its stated purpose, U.S. District Judge Brian Wimes wrote in a March 7th order. He continued, while purporting to protect citizens, SAPA exposes citizens to greater harm by interfering with the federal government's ability to enforce lawfully enacted firearms regulations designed by Congress for the purpose of protecting citizens within the limits of the Constitution. And then Missouri Attorney General Andrew Bailey immediately said he would appeal the ruling. There's a lot of Second Amendment protection acts out there. I tried to find the difference between Missouri's and all the others. The only thing I could find, and I don't have this in front of me, but I believe Missouri just made it illegal, period, to enforce Second Amendment law inside the state of Missouri. That means it's illegal for federal agents to try to do it. I think that's where this ruling comes from. Am I missing the mark here?
No, I think you're exactly right. So insofar as Missouri says we're not going to designate any of our own resources to enforce what we consider to be unconstitutional federal gun control, that's okay, because the federal government can't commandeer the state government or the state government resources to effectuate federal government laws. That's called the anti-commandeering doctrine. But if Missouri interferes with federal agents enforcing federal law, that's where this court is saying the Missouri law goes too far. That's an interesting issue because obviously there's disagreement about what's constitutional here. And I like the Missouri law because it's one of the stronger Second Amendment preservation acts. It has some teeth to it because it says, hey, you can't come into our state and enforce what we consider to be unconstitutional laws, or else there's going to be a consequence. And laws without consequence don't have much effect. So I like it in that regard, but I think this court said it goes too far because it interferes with federal government agents enforcing federal law. It's okay if state government agents don't enforce federal law, but you have to let the federal government do what they're going to do.
Yeah, you absolutely do. And let's federal government. It's a huge entity, but if you look at it for law enforcement, it's tiny compared to local, compared to state, city, county. Compared to those law enforcement agencies all put together, federal government is tiny. They do not have the ability to blanket the country and enforce their laws. They have to rely on local law enforcement to help. And Missouri's saying, look, we're not going to do that. Other states have said we're not going to do that. The only difference is Missouri put a criminal penalty if you tried to. That's what I've seen, at least.
Yeah.
I want to go on to regular news, and again, Michigan is right up there. I got this story off of DetroitNews.com. I'm going to read a bit of it. Before approving an 11-bill package Thursday aimed at combating gun violence, a Michigan Senate committee changed one of the proposals to remove from current state law legal protections for firearms dealers and manufacturers. Democrats made the liability changes in a bill that previously focused on bolstering gun storage standards in homes where children are present. Republicans immediately criticized the revision. The new revision would delete about 2 pages of law. They say federally licensed firearm dealers are not liable for damages arising from the use or misuse of a gun if the sale was executed legally, and that ban local governments in Michigan from suing gun manufacturers. I'm going to go ahead and leave it there for a little bit. What they're saying is basically we're going to allow people to sue gun dealers and manufacturers out of existence. That may work for dealers in Michigan. They may close all the gun stores in Michigan. However, there's the federal PLCAA, Protection of Lawful Commerce and Arms Act, that says you cannot sue manufacturers if they do not make a defective weapon. And so, yeah, can they do this inside of Michigan? There's going to be lawsuits that try to stop it after the law is enacted, but they cannot do it federally. What do you think, Alex?
Yeah, so it sounds to me like Michigan has a law that is similar to the PLCAA, the Federal Protection of Lawful Commerce and Arms Act, and that the proposal here is to delete that provision of state law. And so the dealers and manufacturers in Michigan would still have the protection of the PLCAA, but what the anti-gun advocates in Michigan are wanting to do is to try to get around the PLCAA to the extent that they believe they can. And that's primarily based on, and we saw this a little bit in Connecticut, based on how the dealers, the manufacturers market their products. So they're saying basically we can sue these companies if they engage in deceptive marketing practices or if they encourage the misuse of their products. But I think that it's a stretch, and I think that getting around the PLCAA is going to be very difficult for them to do. Because listen, we don't treat any other industry like this. People who use a Ford vehicle or a Chevy vehicle and drive drunk, that doesn't make Ford or Chevy liable for the misuse of their product. And that's exactly what they're trying to do here with firearms manufacturers and dealers, is to say if somebody uses your product in a way that is bad, you're going to be liable for it. And I think that's clearly just a way to try to put the firearms businesses out of business.
Yeah, you're absolutely right. And I think that's really nationwide. That's been a focus for the anti-gun groups, is to try to get around PLCAA by going after manufacturers, and it doesn't matter where they're from. They've been trying to do it nationally, like I said, going after manufacturers for deceptive marketing. And I cannot recall personally seeing a deceptive ad for these for any manufacturer. That includes the one that we've been going after. The really bad is JR-15, the slightly downsized version of the AR-15. That's fantastic for kids, and even there they're trying to say that it's deceptive marketing and marketing to children, when obviously everything on the website that I can see, although they have a young lady holding it, there's dad right over her shoulder in contact distance. So I'm biased. I'm pro-gun myself. I don't see where they're going to get anywhere with this, but it's the law. You never know.
Yeah, I don't think so either, but by repealing or getting rid of this provision in state law, they're at least taking one impediment out of the way. So I think that's their angle, and they only have to grapple with the federal protection if they get rid of the state protection as well, which could be more protective than the federal law. I haven't read the actual text of the Michigan law, but in many cases, state law is more protective than federal law.
Yeah. Speaking of state laws, I want to go to Oklahoma quick, and this is a little bit of a good news one, although I'm going to take the newspaper to task. This is the Oklahoman.com newspaper. Oklahoma expanding castle doctrine to entire property. House Republicans advanced a bill Thursday to extend the area where a person can defend themselves with a firearm. An expansion of the so-called castle doctrine has been a top priority for pro-gun groups for years. House Bill 2049 changed the definition of dwelling from a building or house to the edge of the property line, possibly justifying a person's use of deadly force to protect themselves as long as they are on land they own or rent. Also referred to as stand your ground laws, Oklahoma law does not require a person to leave a situation if they feel threatened. Instead, current law states someone has a right to stay and shoot a person who is threatening their safety as long as they are as long as they are in their home. That's not what stand your ground laws and castle doctrine. Basically, my understanding is castle doctrine has always applied to your home, to your domicile. That's castle doctrine. Your house is your castle. Stand your ground, an entirely different beast, meaning you are not in a duty to retreat before you defend yourself. You still have to have a viable threat. You just are not required to retreat before you use deadly force, if deadly force is authorized in your situation. What do you think, Alex?
Yeah, so castle doctrine and stand your ground mean slightly different things depending on which state you're in. So I want to be clear that each state could apply these doctrines slightly differently, which is demonstrated by this article, right? I mean, Oklahoma is expanding the meaning of castle doctrine and the applicability of castle doctrine, not to just within the home, but also to the edge of your property, wherever that is. But generally, what castle doctrine does is removes, kind of like stand your ground, and I'll get to the point here, to the difference here in just a moment. Castle doctrine removes the obligation or the duty to retreat in your home or from your home. So if you are in your home, you do not have to retreat either to the farthest place. There have been laws in some states in the past that required you to retreat as far as you could within your home before you use deadly force. You do not have to do that if your state has castle doctrine. There is a legal presumption that if someone is breaking into your home, they intend to do you harm, and you are justified in using deadly force, and you do not have to retreat. Now, that's a rebuttable presumption, so you should make sure that you are justified in using deadly force, and that the person isn't running away, or that the threat ends just because they're still in your home. If they're running away, the threat may have ended, and your right to use deadly force would have ended as well. So that's castle doctrine. Stand your ground extends that to outside the home. So if you are in public and you're in a place where you have a right to be, stand your ground laws say you do not have a duty to retreat if you're facing a deadly threat or a threat of great bodily harm. So it's basically an extension of the castle doctrine to the public if you're in a place where you have a right to be. Now, castle doctrine historically has extended to what's called the curtilage. So not just in your home, but also maybe if you had a fenced-in backyard or an attached garage. There's been sort of this amorphous concept called curtilage, the place where you engage in the intimate activities of daily living. And Oklahoma here is saying we are going to extend castle doctrine not only to curtilage, but to the edge of your property. So it's taking a more expansive view of castle doctrine than most states take.
This is encouraging to me. I honestly would like to see every state, and let me get a comment from 500 Magnum up here. He says, we have stand your ground in Georgia, thankfully, although it should be the law of the land. I agree. I would like to see stand your ground be the law of the land in all 50 states. We have it here in South Dakota, and we've just recently got castle doctrine being in the last 5 years. We didn't have it previously written into the law, but we don't have blood running in the streets here. I'm pretty sure Indiana has it, and you guys don't have huge problems with just shooting the paperboy or anything like that. I'd love to see it go nationwide. I think it would be better for our rights individually, better for us individually, and better for the nation as a whole, because home invasions are going to go down if that happens.
Yeah, in fact, stand your ground states don't have blood in the streets like the media likes to portray. Stand your ground simply protects the innocent person from having the obligation to retreat. And often having an obligation to retreat puts the innocent person in greater danger. So it's removing that risk and that obligation to retreat And so that will obviously make the criminal less likely to engage in their attack if they know the person does not have to run.
Yeah, absolutely. We got more comments coming in I want to get to here. First one from gun websites. I don't think of stand your ground laws as refusing to retreat because they give the victim of the crime the ability to defend themselves without being required to know the intent of the bad guy. And what I'm going to say is somebody's been through a lot of training. Alex, you're a trainer. You've been through a lot of training yourself. Matter of fact, we met because we had both been through Masada Yub Group's Mag 40, and we met at Indianapolis NRA show the last time it was there when I interviewed you and your father at the ACLDN booth. But so we both been through a lot of training, and stand your ground doesn't necessarily mean you can't retreat. It means you don't have to. In a lot of cases, that is tactically sound. Retreat before you have to act is tactically sound, and I'll never fault anybody for that. It just gives us options that sometimes that weren't there before, right?
Yeah, exactly. We always, when we have classes, emphasize that if you can avoid a deadly encounter, you should absolutely avoid the deadly encounter, because there are all sorts of collateral consequences to that use of force, both psychologically, legally, etc. So avoid the use of deadly force if you can. But that doesn't mean you should have a legal obligation to retreat, because that legal obligation puts the innocent person in danger. So try to avoid it if it's at all possible to do so safely. But if you can't, I think these stand your ground laws tip on balance in favor of the innocent person rather than the criminal, which is the way it should be.
Now, before I read this next comment, I need to give out a disclaimer. Alex is an attorney. He's an attorney in Indiana. He's not giving legal advice to anybody, including people in Indiana. If you need a lawyer, get a lawyer in your jurisdiction. We have a comment come in. Doesn't Castle Doctrine also apply to defending yourself from within your automobile in most states? I think, Alex, in some states it does. I'm not entirely sure. I don't know if most states is accurate.
Yeah, I don't either with respect to most states. That is true in Indiana. If you are in an occupied motor vehicle in Indiana, Castle Doctrine applies, but it has to be occupied. So you can't, if you see someone trying to steal your vehicle in a parking lot as you're walking out of the mall or a Walmart, you can't use deadly force to prevent them from stealing your car. But if you are occupied, if you are occupying your vehicle, you are in your vehicle, then Castle Doctrine would apply in Indiana.
Okay, yeah, and that's if you need that for your state, research it yourself, get a hold of an attorney in your state, but nothing that either of us are saying. And you should never rely on me for legal advice, but nothing Alex is saying is legal advice. Excuse me. One more comment here, and then we'll move on. Actually, one more comment, then we got to start shutting the show down. It's almost the end of the half hour here. Going back to gun websites, I think of stand your ground as my grandma doesn't need to know if that guy is breaking in to rob her or kill her, or I think that's fairly accurate. You don't have to find out what their intent is. If they're coming into your house, they're not there for milk and cookies.
Yeah, I want to caution people. You do have to so there have to be certain elements present before you can utilize deadly force. The person has to have the ability to engage in an act that would either cause you death or grave bodily harm. They have to have the opportunity, and they have to have the manifest intent. You have to be in jeopardy. And so there has to be some indication that they intend to do you harm. You don't have to get inside of their mind, but there has to be some action that they've taken that would lead you to believe, lead a reasonable person to believe that they are about to do you harm. So it's not that you don't have to know their intent at all, but you do have to have reasonable circumstances where a reasonable person would believe that they're in imminent danger of death or great bodily harm.
And I'm admittedly stealing this directly from the master himself, Masada Ayub. When I say that he is, Masada Ayub said, he uses the term CYA. It's not cover your, it's can you articulate. And if you can say why you did what you did with reasonableness, that is what generally the legal arena is looking for. Can you explain why you did what you did?
Yeah, exactly. Because that's what you're going to have to, if you have a trial and you're in front of a jury, you will have to articulate, just like you said, Paul, why you did what you did.
Yep. We are down at the bottom of the hour, Alex. We got to get out of here. You'll be back for the weekend edition of the Bullet tomorrow if I can pull you off your motorcycles. But if I could real quick, Forge of Freedom podcast and anything else you want to plug today. What you got, man?
Yeah, so I started a new podcast at the beginning of the year. It's called The Forge of Freedom. I'm an attorney. I'm a firearms instructor, but that's not my passion. I love those things, but more generally, my passion is freedom and creating a freer world and helping people live a freer life. And at the Forge of Freedom podcast, we talk about the Second Amendment, we talk about firearms, but we talk about other topics as well related to freedom. So if that's something that's interesting to you, check it out. It's on YouTube, Rumble, and most of your podcast streaming sources. I also want to say, too, that my father is also an attorney, and we teach a 5-hour legal class about the legal concepts that we think people need to know if they carry a firearm or have a firearm for self-defense. And we're teaching a class here in Indiana, April 2nd. If that's something you're interested in as well, check out our Facebook page at the Forge of Freedom for more information.
Very cool. On my end, I'm going to say that wraps up the Monday through Friday versions of the Bullet, the short 30-minute ones. Come join me tomorrow. Well, me and Alex will be back tomorrow at noon Central Time for the weekend edition of the Bullet. Also joining us will be Tom Walls of the Firearms Academy of Seattle and Rebecca Schmoy, who, if you are a recent joiner to our show, you haven't seen her yet. She was interviewed a while back on Polite Society podcast a couple of years ago. We interviewed her when she was running for District 59 House in Kansas. She did win that seat. She's been a legislator now for a couple of years. She'll be joining us tomorrow. We'll be talking with her a little bit about what being a legislator is like, and she'll also be joining us to review the week's stories for the rest of the show. Thanks for watching today. Please do come join us noon Central Time tomorrow. Until then, everybody, thanks for watching, and we'll see you next time.